What is a bail? Bail under Rule 114, wherein it is a security given for the release of a person in custody of the law, furnished by him or a bondsman to guarantee his appearance before any court as required under the conditions for law. Bail may be given in the form of a corporate surety, property ban, cash deposit, or recognizance. Take note that bail is only available to person who is in custody of law. And the purpose for bail is the guarantee the accused for appearance in court, the temporary released, but he is required to attend any court hearings in relation to his case. The constitutional rules on bail. As a general rule, all persons before conviction for criminal offense shall be entitled to bail. This is under Article 3 of Section 13 of Article 3, the Bill of Rights. The suspension of the privilege of habeas corpus does not impair the right to bail. So, if there is already suspension for the privilege of habeas corpus, the right to bail is not affected, and no excessive bail shall be required. Bail as a matter of right and as a matter of discretion. If it is a matter of right, if the case is filed before MTC but before or after conviction, the bail is a matter of right. And at the same time, before conviction of offenses not punishable by death, reclusion perpetua, or life imprisonment is also bail as a matter of right. So, bail is a matter of right if it is before or after conviction in the MTC, while before conviction of the offenses not punishable by life imprisonment, reclusion perpetua, death penalty in the RTC. When it is already as a matter of discretion, lies in the sound discretion of the court. If upon conviction of the offenses not punishable by death, reclusion perpetua, or life imprisonment, so after conviction, it is already a matter of discretion. It lies in the sound discretion of the court. And the second one is that charge of offenses punishable by death, reclusion perpetua, or life imprisonment. So, if the offense is with a penalty of life imprisonment, death penalty, or reclusion perpetua, the bail here is already a matter of discretion. It is already depending on the sound discretion of the court if it will grant bail or not. Where to file bail? So, it should be filed and acted upon by the trial court, provided the original record has not yet been transmitted to the appellate court. So, file petition for bail to the trial court, provided the original records are still in the trial court. You will file only petition for bail to the appellate court if the decision from the trial court changes from non-bailable to bailable. So, go to the appellate court, file their petition for bail if the decision of the trial court changes from non-bailable to bailable. In international law, extradition proceedings are not criminal proceedings. So therefore, the bail here is a matter of discretion. It is not matter of right. However, in the case of Hong Kong versus Olalia, the government of Hong Kong, the right to bail by the extraditee is now relaxed. The reason for granting bail to an extraditee is the Universal Declaration of Human Rights. Under such declaration, it is a generally accepted principle of international law. As such, it will automatically forms part of the law of the land of the Philippines. So therefore, now as said in the Hong Kong versus Olalia, government of Hong Kong versus Olalia, in which there can be already a grant of bail as a matter of right under the Universal Declaration of Human Rights. But discretionary, the right to bail, if it is a matter of discretionary, when there is only showing of clear evidence that the applicant will not be a flight risk, he will not escape, there is no probability of escaping if granted with bail, and there exists a special humanitarian and compelling circumstance. So these are the grounds or circumstances that need to be considered when it comes to bail as a matter of discretion. The matter of the right to bail is not a matter of right, but a matter of discretion on the part of the Commissioner of Immigration and Deportation. It's when it comes to the jurisdiction of Commissioner of Immigration and Deportation, the bail that he will be granting is not a matter of right, but a matter of discretion. Conditions to a bail. Bail shall remain in force if approved until promulgation of judgment. So the duration will last only from the promulgation of judgment. Then after the judgment, there will be no more bail. Another condition to a bail is that the accused shall appear before the proper court whenever required by the court or the rules. Failure of the accused to appear without justification and despite due notice shall be deemed a waiver of his right to be present thereat. In such case, trial may proceed without him. So trial may proceed without him is already trial in absentia, provided there is failure of the accused to appear, and such failure is without justification, without valid cause, and there are several notices. There are due notices provided upon him to attend or to appear before the trial. Surrender ban. The bondsman shall surrender the accused to the court for execution of the final judgment. So that is already the duty of the bondsman to surrender the accused before the court for the execution of the final judgment under Section 2 of Rule 114. When application of bail after conviction be denied. So, you file an application for bail after conviction. It should be denied if the penalty imposed by the trial court is imprisonment exceeding 6 years. The accused shall be denied. Or, if his bail shall be cancelled upon showing by the prosecution with notice to the accused of the bail negating circumstances under Section 5 of Rule 114. So the trial court will deny the application for bail if the penalty of imprisonment is exceeding 6 years and there is clear showing by the prosecution of bail negating circumstances. And what is this bail negating circumstances? So it is when the accused is a recidivist, quasi-recidivist, or a habitual delinquent, or has committed the crime aggravated by the circumstances of reiteration. So that is the first. There can be a bail negating circumstances when the accused is a recidivist, quasi-recidivist, or habitual delinquent, or has committed a crime aggravated by the reiteration. There is reiterating committed by the accused. And the second one is that the accused is previous escapee or violated the conditions of his previous bail without justification. So, is an escapee or violated the condition of his bail without justification. And the third one is that the accused committed an offense while under probation, parole, or conditional pardon. So, committed, violated the parole, the probation, and conditional pardon. And next is that the prosecution shows that there is probable flight of risk. So he might fly to other place to escape. And the last is that there is undue risk that he may commit another crime during pendency of appeal. So there is the probability of committing of another crime. So these are the circumstances that will tell us that there is bail negating circumstances. In Leviste versus CA, if the accused is convicted by the RTC with imposed penalty of imprisonment exceeding 6 years and there is no bail negating circumstances, the grant of bail is still discretionary. It is not automatic on the part of the RTC to grant bail. If one negating circumstance is present, the bail should be denied. So again, bail should be denied if there is bail negating circumstances. But if the imprisonment is exceeding 6 years, the penalty is imprisonment for more than 6 years, and there is no bail negating circumstances, the application for bail lies on the discretion of the court, and it is not automatic for the court to grant bail. Take note that the grant of bail should not be conditioned upon prior arraignment of the accused. Thus, when bail is authorized, bail should be granted before arraignment. So there can be no condition given to the accused for the grant of bail prior to the arraignment. No condition shall be made. No condition shall be given to the accused prior to the arraignment. So when bail is authorized before arraignment, it shall be granted. Otherwise, the accused will be precluded or barred or stopped from filing a motion to quash, which is to be done before arraignment. So, motion to quash is the information is being done before arraignment. This time, let's go to non-bailable offenses. What are those offenses that bail is not accepted or you cannot apply for bail? Who may not be admitted to bail? So, under Section 7 of Rule 114, no person charged with capital offense, death penalty, reclusion perpetua, or life imprisonment shall be admitted to bail. And when evidence of guilt is strong, regardless of the stage of criminal action. So, those person with a crime committed with a penalty of death, life imprisonment, or reclusion perpetua, or when the evidence is strong, so they are not allowed to apply for bail. Now, guidelines in non-bailable offenses. This is in the case of Enrila versus Sandigan Bayan. First is, in all cases, whether bail is a matter of right or discretion, notify the prosecutor of the hearing of the application for bail or require him to submit recommendation. So the very first is that notify the prosecutor that you will be, as a counsel, you will be applying for bail for your client, and notify him the hearing and require him to submit recommendation. The second is that where bail is a matter of discretion, conduct a hearing of the application for bail regardless of whatever or not the prosecution refuses to present evidence to show that the guilt of the accused is strong for the purpose of enabling the court to exercise its sound discretion. Take note that hearing is mandatory in application for bail in non-bailable offenses. So, as a counsel, hearing is mandatory when you are applying for application for bail in non-bailable offenses. Thus, when the prosecution does not have objection for petition for bail and the judge grants the petition on that basis. Then the third guideline is decide whether the guilt of the accused is strong based on the summary of evidence of the prosecution. So it's the court who will decide the guilt of the accused based on the summary of evidence presented by the prosecution. And the last guideline is that if the guilt of the accused is not strong, discharge the accused upon approval of the bail ban. Otherwise, petition should be denied. So, if the evidence presented by the prosecution is not that strong to build the guilt of the accused, and therefore the judge may grant the petition, may grant the application for bail. Guilt is strong, then therefore non-approval of the bail. If the guilt is not strong, then there will be approval of bail. The guilt is being shown through evidences as built up by the prosecution. It is the job of the prosecution to prove the guilt of the accused, and they have the job to contradict the application for bail. Take note of this: when bail is not required. So when will you know that bail is not anymore required? First is that upon order of the court. If the court says that no bail is required, then follow it. Another is that when a person has been in custody for a period equal to or more than possible maximum imprisonment prescribed for the offense charge. So therefore here, the person is already serving for a period equal to or more than the possible maximum imprisonment prescribed for the offense charge. So it means to say, if the penalty under the law requires only for 1 year, but the person is already serving in under custody for already almost 1 year, so he should be released without bail. If the next is that if the maximum penalty to which the accused may be sentenced is destierro, he shall be released after 30 days of preventive imprisonment. So if the accused is sentenced for destierro, to suffer destierro, then therefore after 30 days of preventive imprisonment, he shall be released after 30 days without bail. Third is that in cases filed with MTC for an offense punishable by imprisonment of less than 4 to 1, and the judge is satisfied that the bail is not necessary. So the MTC judge punished the accused for an imprisonment of less than 4 years, 2 months, and 1 day. And he is satisfied that bail is not necessary. So that is, bail is not necessary when it is determined by the MTC judge, as he penalized the accused for imprisonment of less than 4 years, 2 months, and 1 day. The last is that if the accused is charged with violation of ordinances, light felony, the prescribed penalty for which is not higher than 6 months, or a fine of 2,000 pesos or both, where it is established that he is unable to post the required bail. So if the accused violated only the ordinances and light penalties only, less than 6 months, and it is being shown that the accused cannot post a bail, then he should be released without bail. This is under Rule 16, Rule 114. Where should bail be filed? We are talking about bail, but where shall we file for bail? Under Section 17 of Rule 114, as a matter of right, bail in the amount fixed may be filed with court where the case is pending. So, go to the court, file there for application for bail where the case is pending. Next, that in the absence or unavailability of judge thereof, with any RTC judge, MTC judge, in the province, city, or municipality. Next is that if the accused is arrested in a province, city, or municipality other than the case is pending, bail may also be filed with any regional trial court of said place, or if no judge thereof is available, with MTC judge therein. So, the accused is arrested from a province or city different from the place where the case is pending, other than the case is pending. So, example, the case is pending in Zamboanga City, but he was arrested in Davao. So, he may ask or apply for bail in the RTC of Davao, if no judge thereof is available, with the MTC judge therein. That's how simple it is for matter of right. How about for matter of discretion or recognizance? The application of bail may only be filed in the court where the case is pending, whether on preliminary investigation, trial, or appeal. So again, if it is a matter of discretion, only file to the court where the case is pending, whether on preliminary investigation, trial, or on appeal. If the person is not yet charged, any person in custody who is not yet charged in court may apply for bail with any in province, city, or municipality where he is held. So, as long as the person is already under custody of law, he may already file for application for bail even though he is not yet charged with information in court. This time, let's go to recognizance. Recognizance is a mode of securing the release of any person in custody or detention for the commission of an offense who is unable to post bail due to poverty, and that the accused shall be in custody of somebody else. So, recognizance is only a mode of release, another mode of release, and unable make a cognizance because unable to post bail. So, this is only applicable for those who are indigent litigant, those whose gross income and that of their immediate family do not exceed an amount double the monthly minimum wage of an employee, and who do not own real property with fair market value as stated in the current tax declaration of more than 300,000 as stated in the section 18 of Rule 141. So, cognizance can only be made by an indigent litigant who is unable to post bail. So, they will apply for recognizance as a temporary release for the accused. There is no hard or fast rule to determine if one is to be considered an indigent. The courts shall use their discretion in determining whether an accused should be deemed an indigent even if the salary and property requirements are not met. When recognizance a matter of right, when the offense is not punishable by death, reclusion perpetua, or life imprisonment, before or after conviction by the MTC, before conviction of RTC, provided that the person is in custody for a period equal to or more than the minimum of the principal penalty prescribed for the offense charge, without application of indeterminate sentence law or any modifying circumstances, shall be released on the person's recognizance. This is under section 5 of RA 10389. So again, recognizance, we can consider recognizance as a matter of right if the offense is not punishable by death, reclusion perpetua, or life imprisonment, and the case is pending before or after conviction by the MTC or before conviction of RTC, and that person is already under the custody of law for equal to or more than the minimum of the principal penalty prescribed for one offense charge, without applying ISLAW. Always take note that the application for bail, application for admission to bail shall not bar shall not stop the accused from challenging the validity of his arrest or legality of warrant issued, or from assailing the regularity or questioning the absence of a preliminary investigation of the charge against him, provided he raises his objection before he enters his plea before arraignment. So again, application for bail will not stop the accused from questioning the regularity and validity of his arrest, the absence of preliminary investigation, provided he raises this issue, the legality, the validity, raises it before he enters his plea or before arraignment.